So, welcome everybody to the latest seminar in our Alumni Seminar Series. And this one is run in collaboration with our Human Rights Law Centre. And the director of our Human Rights Law Centre is here with us today, Maris Ains, thank you for coming, and other members of the centre who are also here today. I'm Mario Mendez, and I've been chairing this seminar series, and it was conceived as a way for us to interact with our alumni and to continue to keep in touch with each other. Speakers thus far have all been full-time members of staff. Some, like Professor Amos again and Professor Hines, are here with us today, or they have been alumni. And two of the prior speakers, who are both on the screen, are former alumni. So earlier in the year, Professor Iria Jufrida gave a talk on the artificial intelligence and the impact on the practice of law, and another former alumni, Zachary Phillips, gave a talk on climate change litigation and cases that he is involved in that are taking place in international fora. And today we have the first of our speakers, who is a visiting law professor, and I'm delighted that Dan Squire was able to accept the invitation to give today's talk. Dan is a King's Counsel and a barrister at Matrix Chamber. He also sits as a Deputy High Court Judge. As you will have seen from the sign-up details, he has a wide-ranging public law practice and has been involved in leading cases before the highest UK courts and before the European Court of Human Rights, with a particular significant theme of his practice being equality law. We actually give attention to some of the cases that he has argued, the many that he has argued, in our compulsory public law module that all our undergraduate students take. And I'll just highlight two of those cases because both were at the UK Supreme Court. One of the very first cases, in fact, the first appeal before the UK Supreme Court, is one that Dan argued, which is the Ahmed case concerning the implementation of UN Security Council resolutions in the United Kingdom via delegated legislation. That was a good 15 years ago or so now. And more recently, another case that we highlight and all our students explore, and thus our alumni have also explored this particular case, the Steinfeld case, in which the UK Supreme Court gave a declaration of incompatibility because the UK law on civil partnerships discriminated against opposite-sex couples. So only same-sex couples could have a civil partnership under the law as it then existed. So Dan has also published articles in leading law journals. He's the co-author of a leading text called The Liability of Public Authorities the Negligence Liability of Public Authorities, which is now in its second edition. He has spent periods as a visiting academic in the United States, where he's also taught law. He's also taught here at QN on our master's program, including very recently, and also including on our undergraduate public law program, where he has given guest lectures. So again, some of our alumni will be familiar with him in that capacity. Dan will be presenting for somewhere in the region of about 35 minutes, and this part of the seminar is recorded before we turn to the question and answer session to follow, and that part of the seminar will not be recorded. That will be followed by a drinks reception. So without further ado, I pass the floor to Dan. Thank you.
Thank you. I didn't realize I'd done all those things. Yeah, thank you very much for inviting me. So I'm going to attempt to do a series of impossible tasks, which is first to tell you what the law is that governs the treatment of trans children in school and the law that governs political teaching and political doctrination. And to look at how those issues are thought about through the legal process. Second, I'll set myself an attempt to answer, perhaps with your help, actually, it's a small group, a series of difficult questions about what schools can and can't legally do. And I'll attempt to do all that in 40 minutes to leave time for questions. Third impossible task is that as a cis white male, I'm going to attempt to speak about trans rights, single sex spaces, teaching about racism without too many people hating me or shouting at me. And that's, having given these talks before, not always that easy, because even before, you may know, we're currently in the middle of a government consultation on the approach that schools should take to trans children. We also had the CAS review coming out yesterday. But even without all that, you don't need me to tell you that these are controversial topics. And in fact, topics on which we can't even agree on a shared language. I said that the government's recently produced guidance about trans children in schools, but in fact, the guidance doesn't use the word trans at all. It describes the children as gender questioning children. It may be something which we can talk about why that is. And as we'll see, the other topic I'll look at is how schools teach history, race, what's now happening in Gaza. And again, you don't need to tell you that that's no less controversial. And what I'm also going to try and do, and this is perhaps my most difficult task, is to try and persuade you that lawyers and litigation are a good thing in this particular area. And that it may not be a bad thing that these cultural battlegrounds have turned into legal battlegrounds. And one of that might seem self-interest. I'm a practicing barrister, and a surprising amount of what I've done, at least over the last few years, is litigate and advise schools and parents in this kind of area. But what I want to try and do, again, in the time, is to make a wider point about what this area tells us about the limits of the law, and particularly litigation, but also its possibilities. Because what I want to try and look at is some of the questions in this area the law can't answer, though sometimes expected to answer, but also some of the things the law can do and some of the things the law can answer. Because one of the things in this area is so much that involves people screaming past each other on Twitter. And one of the things that the law, it seems to me, can do is provide at least some shared language and some shared process for which we can talk through some of these things. It doesn't mean in any sense people are going to agree what the answers are, but it does seem to me that there is something the law, and again, particularly litigation, can do in this space. So let me start with talking about trans children in schools and what the legal framework is that governs it. How many people are people very familiar with the Equality Act and just the kind of how it works and the details of it? So I can do stuff relatively quickly on the kind of legal framework. Those are my five legal questions, of which I think two have pretty straightforward legal answers. Three have slightly more tricky, but I think relatively clear legal answers. And what I was going to do, but especially if people are reasonably familiar with how the Equality Act works, is give you literally in 3 minutes the structure of the Equality Act, because all of these, the answers to all these questions, the political indoctrination stuff is a different set, is a different legal regime. But the very basic framework of the Equality Act, again, I'm sure this is very familiar, sort of 3 building blocks. There's Equality Act protects 9 characteristics which are listed there, of the ones of which are relevant are sex and gender reassignment. It then has a series of different areas in which it is unlawful to discriminate, and the relevant one for our purposes, Part 6, which is the education section of the Equality Act, and it then has a series of different prohibited acts. The relevant ones for our purposes are direct and indirect discrimination. And again, this should be familiar, the definition of direct discrimination, less favourable treatment because of a protected characteristic, treating a black child less favourable than a white child because of their race, etc. And which, and we'll come back to this, except for some limited statutory exceptions, cannot be justified. And we'll see some important statutory exceptions that apply in the schooling context. Then in contrast, indirect discrimination, application of an apparently neutral provision criterion or practice, but which disproportionately disadvantages those with a particular protected characteristic, but which can be justified. So that's, there we are, that was about a minute and a half on the legal framework. Turning then to my questions, some of them I'll see if you can tell me the answers, but first one I won't. What do we mean by girl, woman, boy, man? And so I'll answer this one, and the answer is, it depends what you mean. And the reason for that is that if what we mean by man, woman, boy, girl is an entirely circular exercise, because it depends what you mean when you ask the question. Because if you mean by man, woman a biological definition, or what the law sometimes calls a chromosomal, gonadal, and genital explanation, you'll get one set of answers. If you define if what you mean by man, woman is someone who presents and identifies in a particular way, you will get another set of answers. And one, as we'll come on to, is what the law cannot do, is answer an ontological question about what a man or a woman is. What it can do is provide a definition, or more specifically, definitions, because actually there's a series of different definitions of what we mean by man, woman, what we mean by sex, that appears in, there's one context in terms of the law on censuses, there's another in terms of how people are recorded on their passports. But the one that we're concerned with today is the Equality Act definition, and that's the Equality Act meaning of sex. It is sex recorded at birth as defined by, and that's the test from a series of different cases, chromosomal, gonadal, and genital tests. And there's a series of tricky questions about if they don't all unite, if they don't sort of how one defines intersex people, where they don't have, where the different sexual characteristics may not operate in the same direction, or where a person has a gender recognition certificate, it's the sex recorded on the gender recognition certificate, which means that sex, as the law currently understands it under the Equality Act, is neither entirely a matter of how someone presents or entirely a matter of biology. So it's not purely how someone presents, because if someone identifies, operates entirely in one sex, that won't be their legal sex as far as the Equality Act is concerned. On the other hand, someone with a gender recognition certificate may not have physically transitioned in any way, but will still have the sex as recorded on their gender recognition certificate. I say that's the law at present because there's currently a case pending before the Supreme Court. It's an appeal from a Scottish case brought by a group called For Women Scotland, who argue that, their claim is that under the Equality Act, sex is purely biological and the gender recognition certificate doesn't change a person's sex. That was rejected by the Court of Session in Scotland, but it gave permission to appeal to the Supreme Court. In fact, at the moment, I'm applying to intervene in that case for another group. The way the law currently operates, is currently understood, and I think I have to say correctly, is that that's what the Equality Act means by sex. As far as schools are concerned, however, no one can get a gender recognition certificate until they're 18, and therefore, if one is thinking about school children, their sex will be their sex as by a biological definition as ascribed at birth. And so if one then, so that a trans girl, however she may present, will have a legally male sex at school. Second, a bit of definition is what we mean by trans. And I say the government guidance doesn't use the word trans. In fact, the Equality Act doesn't use the word trans, it used the word, maybe this tells you when the act was past used the word transsexual, which is defined as someone who has the protected characteristic of gender reassignment, which is someone who is has undergone, is proposing to undergo a process of reassigning their sex. And that is the protected characteristic of gender reassignment, and that is defined as someone being trans. And the way in which that's been interpreted by the courts is that anyone who has taken any steps, whether it physically, socially, or in any way to adopt attributes that are different to the sex they were registered at birth, will have the protected characteristic of gender reassignment. They will be trans. And in fact, the way you may notice, the way the courts have interpreted that, the way the legal definition appears to envisage someone moving from one sex to the other, which wouldn't appear to include people who are non-binary. The way in which the courts have interpreted is it includes people who are non-binary, anyone in that sense who would describe their sex in some different way to their legal sex, will have the protected characteristics of gender reassignment. So there was my rapid legal framework. And now some questions, which I want to look at questions we can and can't answer. Can a girls' school exclude a trans boy who is a current pupil at the school on the basis they are a, quotes, girls' school and the pupil identifies as male? Anyone go? Can a school lawfully do that? Correct. Easy. There's an easy legal question. The answer is because that would be direct gender reassignment discrimination. The pupil's legal sex is female. The fact that they identify as male doesn't change their legal sex. If they're being excluded, they're being excluded because of their protected characteristic of gender reassignment. And there's a statutory exception, unsurprisingly, for single-sex schools, because otherwise they wouldn't be able to exist, which allows them in admissions to discriminate on grounds of sex. But this would be discrimination on grounds, A, of gender reassignment, not sex, and it's discrimination and it's an exclusion. Another easy one. Can a boys' school refuse to consider application for admission from a trans girl on the basis she identifies as female? Same answer. Another easy one. And it's exactly the same. It's exactly the same set of issues. It's gender reassignment discrimination, which isn't permitted of a single-sex school. Next question is, can a girls' school admit a trans girl? So this is a child who is legally male. Can they be admitted to a girls' school? And if so, does the school then lose its single-sex status? Does it cease to be a single-sex school, such it then has to admit, in this case, anyone who's legally male? Because the statutory protection only operates if you're a single-sex school. You're then allowed to discriminate in admissions. Does a girls' school that admits a trans girl lose the single-sex status? Can it do so lawfully? Does it lose its single-sex status?
It does lose the status.
Yes, correct. Answer yes. That's what I was going to say. No. Again, and I'll talk a little bit about how kind of the law works in this area. The reason for that is that the definition of a single-sex school is a school that only admits pupils of one sex or admits pupils exceptionally of a different sex. And again, one of the striking things about working in this area of law is that the Equality Act, even though it was only now 14 years ago, feels like an entirely different time. And none of this stuff, I think, was thought through at the time. Because in the definition of single-sex schools, what they'd envisage by exception admission of people of the opposite sex is given in the explanatory notes. It's things like members of staff's daughters can attend a boys' school without it ceasing to be a boys' school, or if you have a local sixth form and there are the girls, they don't teach, and they get the example they give, they don't teach the girls chemistry or physics, can't remember what the explanatory note says, you can then allow some of the girls from the local girls' school to come along. That's what the Act envisaged. But it seems to me there isn't any, I don't think it's ever been tested, but it seems to me there's no particular reason why that exceptionality provision wouldn't apply to if you admit a small number of trans girls, or here it's trans girls to a girls' school. But it then does start to become a lot more tricky as to what exactly you mean by exceptional in those circumstances, because you now are admitting people who are legally male to the school. Ought that to be regarded as an exception in the way in which the Act envisaged? As I say, I think you can certainly read the Act in that way and say, well, no, that remains literally an exceptional admission, therefore it's lawful. Now, I didn't put in, there's a much more difficult legal question, which I won't attempt to answer on my feet, which is if the girls' school refuses to admit the trans girl, does it have a legal obligation to at least consider admitting the trans girl? Can it simply say, I'm terribly sorry, we are a girls' school, you are legally a male, we don't even have to consider your application? That is a really difficult question. We can sort of chat about it, but perhaps later on. But then is the school required to treat a child in the agenda in which they identify? Answer to that, not necessarily. If not, what obligations, if any, does the school? Since I've got to type it there. What obligations the school does the school get rid of the word they owe a trans child? So on one level, an enormously unsatisfactory set of answers, but it seems to me, well, A, legally correct, and B, actually, there's real value in some of those answers. And the reason for those answers may be relatively clear. But the situation arises, what happens if a pupil wants to be treated in a way that's consistent with the gender in which they identify and present, but may not reflect their legal sex? This is what the current government guidance, I think the CAS report also calls it, socially transitioning. Pupil who's legally male wants to use, but identifies as female, wants to use a female name at school, wants to play in the girls' sports team, wants to use if there's a school uniform, wants to wear the girls' uniform. The answer is the school is certainly not required to treat the child in the sex in which they identify, but and this is perhaps the important part, this is why it depends on the circumstances, that if the school refuses to treat the child in the sex in which they identify, it's going to need to show that that's proportionate. It's going to need to show that there's an objective and reasonable basis for the refusal. And the reason for that is that it's going to be at least prima facie indirect discrimination to refuse to allow a child to socially transition. Because what in effect the school is doing there, is applying if you remember the definition of indirect discrimination, if you apply a provision, criterion, or practice which disproportionately disadvantages people with a protected characteristic, that has to be justified. And so a rule that says a child has to wear the school uniform of their legal sex is going to disproportionately disadvantage children who are trans, or a child has to wear play in the sports team of their legal sex, or if you take on perhaps the more subtle one, and this is one that seemed at least featured to a significant extent in the government guidance, people who want to change their name. So even if a school doesn't necessarily have some written policy about name changes, presumably they have a series of practices as to what they do. And one assumes that for most schools, if a child comes in and says, well, I'd like to be known by a name which is not the name I'm registered at the school, presumably in some cases, the school will say yes. In some cases, if you come along and say, I'd like to be known by King Alphonse VII, the school will say, clear off. And what you're then doing is applying some form of practice. And that, again, is a practice that is likely to disadvantage, if the practice is refusal, or at least the school, it's up to the school whether it will allow a person to change their name or to be known in the classroom by a different name to the one they're registered, is likely to disproportionately disadvantage trans children, who are obviously more likely, there will be other children who want to be known by a different name, but more likely to want to be known by a different name. And what that means is the school has to justify the decision in the individual case. There's again, something I won't give an answer to, but again, there's a really quite difficult question about whether pronouns, whether refuse to allow someone to be known by a different pronoun is actually direct gender reassignment discrimination, because the only category of person who is likely to want to be known by a different pronoun will be someone who's trans. And so on some analysis, you could say as a matter of logic, therefore refusing to call people by a different pronoun ought that to be considered direct discrimination, which can't be justified. You can tie yourself into all kinds of conceptual knots about that. I strongly suspect if something like that ever came to court, the court would regard it as indirect discrimination, because otherwise the school would be in a position where it would simply have to accede to whatever request was made in relation to pronouns. I think the way in which a court would approach this is to say any decision on social transitioning is potentially indirectly discriminatory, and therefore the school has to justify its decision. And it seems to me that that's actually right, and that is actually how the law ought to approach these questions. One of the things that's said in the government guidance, and it appears in the CAS review as well, is that social transitioning isn't a neutral. It's not a neutral act, is one of the things it is said. It has consequences for other children. It has consequences for the individual child, and I think that's right. One of the striking things about the government guidance is that it doesn't recognise that refusing to allow someone to socially transition is also not a neutral act. That also has consequences for the child, for the wider school community. And the way that the government guidance is written is there's a suggestion that there is a strong presumption that children shouldn't be allowed to socially transition, and there's some suggestion that primary school children should never be allowed to socially transition. And it does seem to me that is problematic. It seems to me the correct legal answer, and I'll come on to why I think it's also a good answer, a good policy answer as well, is that you, the school, have to think through what the consequences are of saying to someone, you can socially transition, you can't socially transition. And then what you end up with is a proportionality exercise. And as you know, if you've ever got into litigation here, and that's ultimately a question on the facts. You have to come forward and say, this is the evidence that we have, these are our sets of concerns if we don't allow the child to socially transition. And these things become really quite granular. If you're talking about a changing area, does the changing area have cubicles? It may be different if the child is 11 or if the child is 14. Those are all, on one level, seem like granular micro questions, but ultimately that is what you do when you look at a proportionality balancing exercise. And it seems to me that's also the right way, or a helpful way, to look at these sorts of questions, as opposed to having, and there will be people who think children should almost never be allowed to socially transition. They also almost always be allowed to socially transition. And I'm not going to answer that. And the law doesn't have answers to those sorts of questions. But what it does do is if those sort of situations arise, I'll come back to maybe this at the end, actually, there's been a striking lack of litigation in this area. And actually, I think litigation would be enormously helpful. And even more so, I'm not going to talk about today, about all the same issues arise about single-sex spaces. It's a different, people may feel it's a different, a much more sort of tricky legal framework, but ultimately most of it comes down to proportionality exercise. There seems to be, there'll be enormous value in having these things actually determined by a court, which is, as a court does, able to look at evidence and able to hear from effectively both sides as to what the consequences would be, and come up with an answer, whether that's a satisfactory one to everyone. It almost never is in litigation, but it provides a way to look at those things. Let me, when we come back to that, what's my time? Let me go relatively quickly just to the other set of issues, or the other bit of the sort of, well, there's many bits of other bits of a kind of cultural war picture and picture as it affects school, and that's about which may be less familiar, or at least a legal framework that may be less familiar, about political teaching. And as you point out, it doesn't apply to universities, does apply to schools. This is the provision that applies to the provision that applies to state schools. There's a similar, slightly more complicated, but essentially the same legal regime applies to independent schools. And it's got sort of three building blocks or three bits to it. One is that junior pupils, that's pupils at primary school, cannot be permitted to engage in partisan political activity. And I'll come in a moment what some of the words mean. Two, teachers are prohibited from promotion of partisan political views. And three, where political issues are brought to the attention of pupils, schools must ensure they're offering a balanced presentation of opposing views. And the second two blocks of that are often dealt with together. In a sense, they're quite hard to separate conceptually. If you're promoting partisan political views, that's often likely to be the same as bringing political issues to pupils' attention, but without giving a balanced presentation, without giving an opposite set of views. And this has been interpreted in a number of different cases. The main one's a case called Dimmock from about 2007, so a while ago now, which was about a video that the Department of Environment were circulating in schools, which was it was Al Gore's film, An Inconvenient Truth. And Mr. Dimmock brought a challenge to it, saying this was political indoctrination, and there wasn't a balanced portrayal of opposing political views. And ultimately, the case was initially, or at least it was initially accepted, I think, at the beginning of the litigation, that it was correct that at least some of the views expressed by Al Gore in the video were regarded as partisan political views, and that it was held to be unlawful for that video simply to be shown at schools. The Department for Education then produced a sort of teacher's guide, which teachers were expected to then talk through with pupils, which presented some opposing political views, and that was then regarded as satisfying the requirements. And what the court then said is various sort of fairly sensible things. What does a balanced view mean? It doesn't mean you have to give sort of mathematical calculation of airtime, but what it means is if you do present some particular perspective, you also have to present what is a different political perspective. What does it mean by partisan? It means effectively something akin to indoctrination, so giving just a political perspective without suggesting that there are alternatives to it. And then But the most difficult question is one I'll race through to it is, what do we mean by political in this context? Because that's probably the most difficult issue that this raises, because when you talk about a political view, you can mean different things, or potentially mean two different things. One thing you can mean is the promotion of particular political parties or particular laws, particular legislation, kind of politics with a capital P. And it could be foreign policy, it could be what a country does abroad. You can think of that as politics with a capital P. But we can also understand politics, what I mean by politics much more broadly, as any sort of worldview, anything about how power is distributed in a society, around gender, race, class. Almost any issue of social or ethical importance can be regarded as being political in that sort of worldview sense. And one of the things, that's an issue that the courts have skated over, but insofar as this has hit schools, one of the things that has happened over the last couple of years is a number of government statements suggesting that politics means this much broader political view, politics with a capital P. And what I wanted to do, so I did have some other tricky questions, but I'm not going to answer them. I'm going to move on to this, which is what the meaning of political. So in some ways, that's the most interesting. So there's some quotes. The reason, reason this issue has become so controversial, the reason it became a political issue in itself was, if the last year has all been about trans children in school, the year before that, it was all about how you teach the Black Lives Matter movement and particularly teaching about critical race theory in schools. And there were various comments made by government about this issue. This was in October 2021. There was the government responded to an education committee report on called "The Forgotten: How White Working Class Pupils Have Been Let Down and How to Change It." And the government's response said this: schools should not teach contested theories and opinions as fact, and this includes contested views about white privilege. And the year before that, October 2020, Minister of Equalities, Kemi Badenoch, who's also actually the minister responsible for the trans guidance, said this in Parliament. Lots of pernicious stuff is being pushed, and we stand against that. We do not want teachers to teach their white pupils about white privilege and inherited racial guilt. Let me be clear that any school that teaches those elements of critical race theory as fact, or that promotes partisan political views, such as defunding the police, without offering a balanced treatment of opposing views, is breaking the law. And what followed from that, or what the government then did in order to sort of put that into effect, in February 2022, it produced guidance on political impartiality in schools. And particularly the idea was to stop schools teaching what it described as critical race theory, and particularly this idea that you shouldn't be teaching, what was the language, white privilege as fact. Now, what that seems to suggest is a much broader understanding of political. That's politics with a small p. Calling to defund the police, you can regard as politics with a capital P. That's about a government policy. But to suggest that teaching about white privilege or other things that are attributed to critical race theory about structural inequality and race and racism goes far beyond party politics or government policy. It's small p politics. So that's my summary of kind of a encapsulation of kind of critical race theory, at least, or one version of it. There's some other. Any idea where the first quote comes from? Huh? First line. Second one? Actually, it's only the second bit of the quote that's a real quote. Arc of history of moral universe long which bends towards justice. Martin Luther King, a week before he was shot. So put those as versions of ways you can teach history. And I suspect that most of the version of history that I've got was a version of was a version of B. But the question is that any less a political way of teaching than A or C? And the difficulty is, of course, that any way a school teaches history is a series of those sorts of political choices. I mean, when I studied English and European history in the last millennium for A level, I did European and English history 1783 to 1900. And as far as I remember, the only thing we were taught about empire and colonialism, as far as I remember, was that Disraeli made Queen Victoria the Empress of India in 1877 to get at Gladstone. So I distinct to remember. I had to look up the date, to be honest, but that was the only thing. Now, that's obviously a political choice to teach that version of history, just as it's an equally political choice to teach about colonialism, to teach about empire. And actually, I didn't give you the full Martin Luther King quote, because actually what he said is, we shall overcome because the arc of the moral universe is long, but it bends towards justice. So, progressive views of history equally have politics embedded in them. And of course, it might not be good pedagogy to teach pupils that history is the history of class struggle without giving alternative political viewpoints, or alternative ways of understanding history. But the problem is, as soon as one starts to regard the way in which critical race theory as politics, and therefore if you teach from that perspective, is that then any choice one makes about the curriculum, any choice one makes about who one does and doesn't teach in an English literature course, is a political choice. So where do I get to with all of this? And let me just try and bring this very, very briefly together. It's this: if you expect that the law is going to be a neutral tool that tells you whether you can teach history from one perspective or another, it can't. The law can't solve political disputes by pretending they're not political. And it's the same with some of the gender and trans issues. If people simply have different beliefs about what a man and woman is, that's not something the law is going to solve. But what the law can do is deal with consequences. So if you define political as politics with a capital P, you can then go forward. That was the examples I gave. You can certainly talk through what things are and aren't. The law can provide a way of resolving those things. And it's the same with the trans issues. When you talk about should a trans woman, it's always trans woman in this context, be allowed to use a woman's only space, the law has mechanisms to talk through that. And it seems to me that's enormously valuable. It's enormously valuable to have a language and a litigation process where those sort of things, so long as we're aware of what the limits of the law are, is an enormously valuable to have that sort of ability to at least talk in the same way and focus on what ultimately becomes a legal question or a legal and evidential question, which there is some basis and there is some way in which the legal process can resolve it. And it seems to me, oddly enough, as you say, litigation, legal battle. I mean, these have become these culture wars have become legal battlegrounds, because that's often how that tends to happen. You have social battlegrounds, they become legal battlegrounds. But this is one where it seems there is some value actually in this being in actually more litigation in this area rather than less, and actually doing this through the law rather than doing it in other spaces. Thank you.
Thank you. Thank you very much, Dan. That was fascinating. I actually forgot to mention what the title of the talk was before I started. It was on the screen, and I'm sure you all signed up to it because you found the topic fascinating. So you all knew what was some sense of what was coming up. So can we open the floor now?